Yo, and what? Jesus Christ, what's going on here? Oh well. Yeah, crap happens. Well, hello, and welcome to today's stream. We are talking about Fani Willis disqualification case for as long as we can. Then we will change over to the Young Thug trial, which is supposed to start 11 a.m. today, but judge is always late, so we have something to talk about. And all the breaks and everything in the Young Thug, we will continue to talk about the Fani Willis Nathan Wade debacle, so to speak. What in the actual F is going on here? Sorry. All right. Yeah, so that's Fani Willis, Nathan Wade, Young Thug trial. You have the whole day in front of you with legal shenanigans. All right. Ta-da! Yeah. Last week, the amount of crap that showed up on Fani Willis and Nathan Wade is hard to believe. I thought they dug deep to find this Nathan Wade Fani Willis thing, but oh no. Somebody got digging, not me. I'm just a messenger here. Somebody got digging and found a lot of crap. And I'm going to go through as much as humanly possible, as much as I possibly can. Where do we start? Well, a week and a half ago, Thursday, Friday, hearing, and Fani Willis stormed the courthouse and demanded to testify, and yeah, there's a lot of channels and Twitters and stuff that says, oh, she really nailed it to... She's an officer of the court. She's not supposed to be a raging lunatic. But she was in court. And things didn't go uphill from there. Oh, no. Oh, Helen, we will get there. We will get there. Easy. We have a lot of things to go through. And maybe a bunch of you... Oh, what's going on here? Oh, hold on. Yeah. Today was an interesting day. Let me get this back up somewhat under control. How much control you can have over this lion mane of mine. Yeah. So, Judge decided last Friday that he was going to have a hearing with Mr. What's his face? Bradley, that's his name. And Nathan Wade didn't really like that. So he tried to do something about it. And what did he do? Well, he did this. Let's see, can I make it larger? Yes, I can. In the Superior Court of Fulton County, State of Georgia, v. a bunch of people. Special Prosecutor Nathan Wade's post-hearing brief on in-camera examination of attorney Terrence Bradley. comes now. Nope. Special Prosecutor Nathan Wade, by and through the undersigned counsel, and files his post-hearing brief concerning in-camera examination of Attorney Terence Bradley by the court, which may unlawfully compel Bradley to disclose communications with Wade that the court has already determined are protected by attorney-client privilege from any disclosure to any person. Nothing under Georgia law authorizes the court to conduct such an examination once the determination has been that attorney-client privilege applies. And should the court compel the disclosure anyway, it would vitiate one of the oldest and most fundamental privileges recognized both at common law and by statute. Blah, 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 blah. But here's the thing. Nathan Wade took the stand and testified. He was asked questions that may or may not have been a part of that privilege. And instead of just plainly saying attorney-client privilege, I have not waived my privilege, he answered a bunch of those questions. And so, yeah. And so it doesn't really matter what Mr. Bradley said. It's more about what Mr. Wade said, in my humble opinion. But they kept trying in this. Moreover, the defendants were allowed broad leeway to pry into the private life of Special Prosecutor Wade in an unprecedented and public manner, spending 2 full days of testimony. Don't fuck your boss. Maybe. Just maybe. Don't lie about it in your divorce proceedings. Maybe. Just maybe. The defendant sought to introduce intrusive and legally irrelevant personal details of multiple people's lives for the world to watch unfold in real time, but still no credible evidence exists in the record to support their tenuous claims. That's not up to you to decide if it's credible or not. If the court were now to discard the most sacred of all legally recognized privileges, end quote, whose, quote, preservation is essential to the just and orderly operation of our legal system, end quote, it would be a step too far, and Special Prosecutor Wade is constrained to object. And they cite. Do you know what another sacred thing is? The position of district attorney and the position of special prosecutor. You are just currently holding those positions. How you conduct yourself in those positions, that matters to the public, to the rule of law, to the court system. It's about the credibility of the justice system. So don't hide behind your office. You are not important. The office is. You are not. You are just temporarily occupying that seat. The attorney-client privilege communication at issue between Wade and his former attorney Bradley, made during the course of and in relation to Bradley's representation of Wade must be protected from disclosure. Any decision of the court to the contrary would fly directly in the face of a long-recognized public policy, quote, to encourage full and frank communication between attorneys and their clients and thereby promote broader public interest in the observance of law and administration of justice. 1981, quote. Here's the thing. Not all communications between two people, even if they are attorney and client, not all communications are privileged. Only if this is in furtherance of legal advice. Mr. Wade bragging on, for example, hypothetical, boning Miss Wade over an office chair while she asked another prosecutor to guard the door is not in furtherance of legal advice. Hypothetical example. I have no idea if that happened. I have no idea. And I really don't want to picture it. Argument and citation of authority. The attorney-client privilege is the oldest of the privilege for confidential communications known to the common law. Georgia statute. The long-recognized attorney-client privilege attaches when legal advice is sought from an attorney and operates to protect from compelled disclosure any communications made in confidence relating to the matter on which the client seeks advice. Again, for example, Mr. Wade talks to you as a friend about, look at this pile of cash that is waiting for me. That is not in furtherance of legal advice regarding your divorce case. Okay. And then here's the court has already held at least 14 times that attorney-client privilege applies to the communications at issue. Here, Mr. Wade. Here, Mr. Wade does an ugly one. The court debated attorney-client privilege and how to move forward with that issue when evidence presented in court may show that some of these communications may not apply to the attorney-client privilege, and that with the regards of the affidavits, Mr. Wade got to the divorce court claiming, I had no relationship with that woman, Miss Wade. If the attorney knows you're lying and still signs, he is in trouble. And your communications might be void. That is up to the judge to decide. As the court has already acknowledged, again, the record clearly shows that an attorney-client relationship was formed when Special Prosecutor Nathan Wade hired Terence Bradley to represent him in his divorce in 2015. There are no papers. But let's assume this is correct, that Mr. Wade waited 8 years. Yeah. 2, the attorney-client relationship existed at least until late 2022, and the attorney-client privilege continues through today. Yes, an attorney-client privilege does not end, even if you stop being somebody's attorney. You have that responsibility to your client, and the only person who can waive that attorney-client privilege is the client. Here's the thing, and I don't want to repeat myself, but I will anyway. Not all communications between two people, even as attorney and client, are privileged. And that's the issue with your Mr. Wade's testimony, Miss Willis' testimony, Mr. Bradley's testimony, is that the judge cannot on its face decide what is and what isn't attorney-client privilege, because there are a lot of information out there. And Mr. Wade testified. Maybe falsely. Dun, dun, dun. Yeah, and then it goes on and on and on and on and on and on. On and on and on and on. Whine, 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 boo-hoo, 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 attorney-client privilege. But yeah, it all ended up with judge saying, I don't have the document. I would imagine, I can imagine, not in plain English. He said, I need to find out what is. And then if I determine that the information you have regarding your relationship with Miss Willis, with Miss Wade, it is privileged, then everything is sealed. Nobody will ever find out. Until somebody takes it to a higher court. But here's the thing. When people screw up, like Wade and Willis did, crap hits the fan for them. It really does. It really, really, really does. So today, now this in-camera hearing, in-camera doesn't mean gonna check. No, it means in the judge's chambers. With the judge, Mr. Bradley, Bradley's attorney, and somebody taking notes. That is 4 people in that meeting today. And Mr. Bradley has to answer. And then the judge makes his ruling. It may be this is privilege, this is not. Then we will find out what that non-privileged is. Since if the judge concludes that Mr. Wade lied under oath in court knowingly, and Mr. Bradley can say with confidence and credibility, this is what happened. And judge determines it's not privileged, that piece of information. Mr. Wade is screwed, in my opinion. Now, how does this apply to Miss Willis, Miss Fani Willis, District Attorney Fani Willis? That is a harder question. At this point in time, I can see Mr. Wade getting a foot in the arse right out. I can clearly see that, even without the privileged information. Because of the filings he did in the divorce court, his changing of the filings he did with the divorce court, and the filings he did into this court, which are somewhat inconsistent. And when I say somewhat inconsistent, he's either lying in divorce court or to this judge. It's one or the other. There's no gray zone here. There's no gray zone. it's up to the judge's discretion. And the person who can get in trouble over the court filings, if he knew Mr. Wade lied in his first affidavit to the divorce court, he could lose his law license. That will be a question for the bar. And Mr. Bradley is probably screwed anyways, because here's the thing. When Mr. Bradley sent text about Mr. Wade to Miss Merchant, Mr. Roman's lawyer, you never talk about named cases. For instance, with colleagues, with cases I handle, I have to be really, really careful and be very, very general. Because if I want to share, for instance, in a case I'm doing right now, if I want to share that because I need advice, then that person, which is my boss, have to be included in that case, to be one of the people in that case for me to share that information. And then he has that secrecy, so to speak, the same secrecy I have. That's the only way for me to get that advice if I need specialized advice. And for Mr. Bradley to just answer and send texts to another lawyer he knows represents a person that has a clear interest, I don't know why he did it. But he, in my opinion, he clearly broke attorney-client privilege. Clearly. So he's screwed. He, in my opinion, Mr. Bradley should not practice law after this. He is not to be trusted, in my opinion, which also speaks against him in the office with Judge McAfee. Neither Wade nor Fani had tried RICO cases. Fani has RICO cases under her belt. She has been a defense attorney for a bit, but she was a magistrate judge or whatever, and she has worked for the district attorney's office a bunch of years ago. So she actually has experience in RICO trials and RICO cases. Mr. Wade doesn't, not one. But as the Judge McAfee said, it is up to the district attorney's discretion who he or she hires as a special prosecutor. And as he said, as long as that person has a pulse and a bar card, it's up to the district attorney's discretion. Gigi says, Niklas, you are having way too much fun covering in the Fani. Yeah. Reading these documents and knowing the thingies around this case is very amusing to me. It is. Because in my opinion, Fani Willis is as corrupt as they come. Which is ironic because she went on her election campaign for district attorney to remove corruption from the district attorney's office. So it's quite ironic. But everybody she hired, also things that showed up last week. When Fani Willis took office, she fired everyone in that office, from more or less from janitor and up. And then everybody had to reapply for their job, which is not uncommon. And you might have noticed it in that hearing. Thursday, Friday, a week and a half ago. Who was there to help hire the people to the office? Nathan Wade was hired by Fani Willis to select the new people for the district attorney's office. Isn't that strange? A person who she claims she only met in a seminar a couple of years back. All of a sudden, he sits there and decides who has a job in the district attorney's office. And to the shock of absolutely nobody, she hired friends, former colleagues, and family. Cousins or something. There's a word for that. Nepotism. That's not a good start, in my opinion. And we see the result now. Yes, even the YSL trial reeks. Yeah. And here's the thing, and I've said this before, and I will say it again. Fani Willis uses the district attorney's office as a stepping stool for the attorney general position. Fani Willis' term ends December 31st of this year, and then she's going for attorney general. Somehow, I think she might have difficulties with that. I have this I have this weird sensation in my brain that she might have difficulties in the next election. Oh. Yes, I know I'm having way too much fun with this. Jokes aside, this is a serious matter because the US justice system rests on the reliability on who works there. And rogue prosecutors have no place there because the system can only be ruined from the inside by well-meaning but incompetent lawmakers and by prosecutors who shouldn't prosecute. Defense attorneys can't ruin the system. They can't. They don't decide who to prosecute. They don't decide who to indict. They defend the people who are indicted and put to trial or make deals. Defense attorneys can never ruin the system. Lawmakers and prosecutors can, and some judges. That's the difference between you and Fani. You think about things more than 24 hours in advance. Yeah, in my line of law, labor law, not only do I have to handle the immediate situation, I also have to keep in mind my two biggest responsibilities is the bargaining agreement and the member. But I also have to look at not setting an accidental precedent in the cases I handle. Because this person, if the bargaining agreement and the client or member are in collide, no, not collide. If I have to choose, the bargaining agreement has precedent. So if I see I can win this case by arguing in a certain way according to law agreement and stuff like that, what can happen is that I remove bargaining chips in the next 20, 40 cases. So I have to play that chess. And that's why all but 3 cases, maybe 4, I've been a long time, I have solved in negotiations. A detrimental precedent. Yeah, I call it accidental precedent. I work in Sweden. It's a bit different here. We have a separate labor court in Sweden with 9 alternating judges. And 6 of them are 50-50 and 3 of them are for the employers. So I have a 33% chance if my cases go to trial to fork everything up. And I really don't want to do that. Oh yeah, hit the like button if you're here. Subscribe if you haven't yet. I'm trying to get to 5,000 subscribers before my birthday in May. So I would really, really like if you did me that favor. Okay, thank you. What's next? Yeah. So Mr. Wade tried to have the hearing not happen today, and he failed. As expected. What happened? Yeah, this I have to about the Fani Willis. Fulton County DA Fani Willis Board of Ethics hearing scheduled for March 7th. That is in a week and a half. Thursday next week. Let's make this bigger. The Fulton County Board of Ethics will discuss 2 ethics complaints against Fulton County District Attorney Fani Willis during their March 7th meeting. The complaints were filed by Gregory Mantell and Stephen Kramer after a motion was filed by a co-defendant of former president in the Georgia election interference case, and knowledge of an alleged relationship between DA Willis and Special Prosecutor Nathan Wade became public. Michael Roman also accused Wade and Willis of profiting significantly from the prosecution of the case at the expense of taxpayers in his motion. And they claim, oh, he made so much money from his private practice, so he really didn't need that money. Nathan Wade, because they kind of pulled his bank records. And it turns out he was appointed November 1st, 2021. October 30th? How many days are in October? October 31st. He had less than $2,000 in his bank account. A year and a half later, we are up to spring of 2023. He had made over $500,000. Yeah, that's kind of an incentive. And what did he do with that money? He took Fani Willis to trips everywhere, food everywhere, doing the doinky doinky doink everywhere. Yeah, he was lucky, I guess. Yeah, that's quite a turnaround. And of course, as you know by now, she claims, oh, I paid him back in cash. Oh, really? Here's the thing. I don't care if you paid in cash. I don't. Or redrawn. I don't care if you claim you paid in cash. If you can't prove it with actual paperwork, You haven't paid back shit, Miss Fani Willis. Not a dime. Because you're not credible, Miss Willis. You lied to the public. You lied in church on a sermon to honor Martin Luther King Jr. You decided to stand up, walk up to the podium, talk to the congregation and the members of Fulton County, the citizens of Fulton County, and you decided to lie to people and to God. You are not credible, Miss Willis. No, just no. I'm not a religious person. When I walk into a church, so I bet you, most of you have that notion. When you walk into a church, you feel something, don't you? Yeah. And Miss Willis walked into church and lied. Yeah, so your credibility, Miss Willis. Oh, I paid him in cash. I don't care. I don't care. No paper trail. No evidence. You haven't paid him back. You gave, in my opinion, personal opinion, you hired him, and as a kickback, he took you everywhere doing the doinky doink. Now, you can claim I'm a bastard and speculation. Objection. I'm on YouTube, not in a court of law. I can speculate. I can have my own opinions. And that's my opinion. Where was I? There. Greg Mantel is the founder of Substack blog Investigative News Service. According to Newsweek, he filed the complaint January 27th. Mantel reportedly asked for Willis' expense report for 2021 to 2023. Yeah. I mean, if some of that was work-related trips to Aruba, I don't care, to a cottage up north, might be. I don't know. I heard a lot of strange places where people have work meetings. Then that should have come out of the district attorney's office account as a reimbursement. There's not a lot of those. Not a lot of those. And yeah, it's clear to me at least. There were no work-related trips. It was, let's go over there and ka-dink. And yeah, as Rico says, I'm going to try that at my IRS audit. Yeah. One more fun thing. Mr. Wade says, oh, I paid it with my business account, and she paid me back in cash. Well, if you pay out of your business account, you have to put the money back, and you claim you didn't. Here's the thing, and I listened to the lead attorney the other day. If you take on clients who comes with cash, sometimes apparently some lawyers choose to not report it because who wants to pay taxes? And remember, in the hearing, Mr. Wade said his income is about 50-50. 50% from special prosecutor, 50% from private clients. You had $2,000 on your bank accounts on October 31st, 2021. If you made 50% of your income from private practice, where's that money, Mr. Wade? I'm not a math person because I do law. I don't do math. IRS have plenty of accountants that all they do all day long, day after day, is math. They can go into the court docket in Fulton County and neighboring counties where Mr. Wade has practiced and look at all these cases. That should have brought him an income around that. What did he report? But it should be here, but it's only there. There's a Mr. Wade, hi, we are from the IRS. We have some questions for you. And here's the thing. You can screw over more or less anyone, take whatever punishment. If the IRS are after you, you will never get away. Never. It's like herpes. You won't get rid of them. But if you work for the IRS, I apologize for that metaphor, but I hope you know what I mean. Mantel claims he was only provided with 2 of the employment contracts and his other requests were denied. Those are public records. Weird, isn't it? The complaint filed by Stephen Kramer contains a series of questions about the hiring of Wade, the relationship between Willis and Wade, Wade's compensation, money spent on dates and trips, possible hostile workplace for their co-workers. Yeah. And better usage of money paid to Wade on items like reducing backlog of cases and number of inmates in jail. And this I have said during the Young Thug trial. That RICO trial, the Young Thug trial, has been going on for 2.5 months now. And I will be genuinely pleasantly surprised if that trial is over this year. Every day in court, in that courtroom, between 4 and 8 cases can be handled. I mean, home invasions, carjack. I mean, many cases can be done in an hour. Misdemeanors and stuff like that. If this trial lasts, let's take an even number, 200 trial days. That is between 800 and 1,600 cases that won't be heard in that courtroom. That is 800 to 1,600 defendants who won't get their day in court to defend themselves. That is between 800 and 1,600 cases where victims won't get their day in court. The Fulton County backlog of indicted cases are around 20,000. Then you have the people who are still awaiting indictment. And the number from Mr. Roman's motion talks about a number of 200,000 cases. Mostly misdemeanors. Yeah. And here's the thing, misdemeanors have a statute of limitations of maybe just a few years. Maybe 2, 3, 4, 5 years. So cases from 2020, 2021 are running out of statute of limitation. Those are real people, real victims, who will never have their day in court because Fani Willis spends money on RICO cases. 4 RICO cases. The young thug, former president, there's a cop something, and then one that was resolved about a month ago due to AFN, whatever his name, another rapper who pled out. He had 13 counts against him, which combined would have given him 2 lifetimes. He pled out to 1 count and got 10 years for that 1 count. That, with pre-trial and everything, took them 11 months, I believe, to get to a plea deal of 1 count. What a freaking waste of time and money. And the Young Thug RICO trial started a year and a half ago with their arrests. Then, in November of 2022, yeah, I know, my chair is creaking. Sue me. Or super chat me so I can buy a new chair. No. Sorry. Where was I? Yeah. They spent 11 months getting a jury. During those 11 months, the prosecution's witness list in the Young Thug case went from about 100 witnesses to 771 witnesses in one trial. About 400 of those are civilian witnesses, and the rest are cops and expert witnesses. Yeah, and here's the thing. I can't oil the chair because it's a wooden frame and steel bolts. So the steel bolts are screwed into the wooden frame. So what the creaking is from the wood, who is complaining about me. So no oil can, no WD-40 or anything. So yeah, I know. I will get a new chair. Okay, I will. Yeah, it's $250 I bought for this because it held 400 pounds. No, I'm not 400 pounds. I'm 260, 270, somewhere around there. Yeah, don't buy cheap stuff. For me, $250 for a chair isn't cheap, by the way. Yeah, so that's about the waste of money and time. And then possible hostile workplace. Yeah, as we heard in the hearing, she got her former friend fired. Allegedly because of she misconduct, or she refused to prosecute cases because she didn't believe she had a case. We don't know. Yet. Kramer also questions the amount of money that is now being spent on dealing with the repercussions of the relationship, an expense that may be borne by taxpayers like Kramer. Yeah, I mean, these hearings are not cheap. There are a ton of lawyers involved in this. Ton of them. Kramer's complaint also asked the Board of Ethics to look into whether Willis used a subpoena of U.S. Senator Lindsey Graham to ask for campaign donations and diverted $488,000 targeted for the Center of Youth Empowerment and Gang Prevention, and used the money instead on MacBooks, swag, and travel. Yeah, Miss Willis, during her time as the district attorney, has asked for extra funds. A lot of it. With the assumption that it was going to be spent on clearing the docket. Doesn't look like that. Doesn't look like that at all. The Young Thug RICO trial, if it ends before, let's say it ends in November, then it has taken 11 months. A rough estimate from incarceration, pre-trial, jury selection, this is easily a $10 million trial. Easily. $10 million that could have been used to clear the docket. And no, because clearing the docket doesn't get you votes to the Attorney General's office. Misdemeanors don't get you elected to Attorney General. RICO cases does. Georgia Rep Marjorie Green also has filed an ethics complaint against Willis. She posted on social media that she was looking forward to the ethics board hearing. The Board of Ethics will meet at 10 a.m. March 7th. The Board of Ethics will then render an opinion on whether Willis violated the county's ethic code. Yeah, I mean, they lied about their relationship. They tried to hide their travels behind a wall of cash. I would suggest that is an ethics violation. But here comes politics. Here comes politics. Fani Willis runs on a platform as an, let's just say, not Republican. I don't know who is in that ethics board, but if it's a majority of the same political party, yeah, good luck. But then again, maybe she becomes such a liability, they will simply throw her out. We don't know. We don't know. Now we come to something that was one of the first comments. Fulton County DA responds to analysis of Nathan Wade's cell phone records. Although I must check so I don't miss the Young Thug. Dun dun dun. Law and C-word. Oh, wrong one. They haven't even put up the stream for today's Young Thug. That should start in 20 minutes. I must check here so it hasn't been... hold on for a second while I check so they haven't... Dun, dun, dun. Nope. See nothing. Just checking here, just to make sure. Bum, bum, bum. Let's see, Kathy Russon from Law and Seaward. New channel link. Okay, they have what? Why? Okay, they have changed it to Law and Seaward trials instead. Okay, then it says 50 minutes. That's weird, because last week on Friday they said let's go for a start at 11. Apparently not. Okay, but yeah, Trump v. Fani Willis, Fulton Camp, blah 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 blah. Yeah, let's make this big. Former President Donald Trump's lawyers have submitted a supplemental defense exhibit related to the recent hearing to dismiss Fulton County District Attorney Fani Willis. This exhibit seems to contain evidence proving Special Prosecutor Nathan Wade spent far more time at Willis' residence in Hapeville than previously claimed before being appointed to investigate the Georgia elections interference case. Trump's attorneys, blah, 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 enlisted defense investigator Charles Mittelstadt to examine Wade's cell phone records from AT&T. You might ask yourself, how did he get the AT&T records from Nathan Wade? You ask for them. The state can subpoena them, but the defense can ask for it in, a written letter. Please hand it over with legal speak. And AT&T complied. How about that? Somebody at AT&T got the letter. Download, send over. Sometimes it happens. Mittelstadt utilized Cellhawk, an analytics tool regarded as the gold standard in cell phone record analysis by law enforcement. Yeah. But Fulton County law enforcement uses Cellhawk. Remember that. Fulton County law enforcement uses Cellhawk. Fani Willis herself, in the trials she has prosecuted, have used Cellhawk as evidence. Yeah, and Nanya Bitten says state needs a warrant, but defense uses a subpoena. Yeah, thank you. Mittelstadt, employing Cellhawk, established a very conservative geofence near Willis condominium in Hapeville. The analysis disclosed a minimum of 35 instances where Wade's cell phone connected for an extended period to one of the two cell phone towers closest to the Hapeville home. It also determined Wade's residence in East Cobb and when his phone pinged off the towers near his home. That becomes important. Trump's legal team asked Mittelstadt to focus on two specific dates, September 11th to 12th and November 29 to 30. According to Mittelstadt's report, Wade's phone arrived in Hapeville at 10:45 p.m. on September 11th and remained there until 3:28 a.m. The records indicated that he sent a text to Willis after arriving home at 4:20 a.m. What was he doing there? Between 10:45 p.m. to 3:28 a.m. Remember, September 11th to 12th is before he was appointed. Isn't that weird? Because Willis said, Wade said, Mr. Wade had never visited her in the pandemonium, whatever's the flat. Still enjoying this. On November 29, 2021, Wade received a call from Willis at 11:32 p.m. at his East Cobb home. His phone then pinged off the tower near her home at 12:43 a.m. remaining at that location until 4:55 a.m. Can you say booty call? These are lawyers, prosecutors. I mean, but if you don't expect to be caught, why try to hide? During last week's hearing, Wade admitted visiting Willis in Hapeville, but claimed it was less than 10 times before being hired as the special prosecutor on November 1st, 2021. Willis also testified that blah, blah, blah. Both Wade and Willis denied he had ever spent the night at the condo. Let's look here again. He arrived 10:45 p.m. and remained until 3:28 a.m. On this next date, he received a call 11:32 p.m., arrived 12:43 a.m., remained there until 4:55 a.m. That sounds like spending the night, doesn't it? Doesn't it? Oh. Bum, bum, bum. Willis and Wade initially met at a conference in 2019, despite a former friend testifying that they began a relationship soon after. Both have testified that their romantic involvement did not commence until 2022. Until then, their relationship was strictly platonic, with Willis considering Wade a mentor. Oh, my mentor. My Fanny calls you. What it could mean. If Willis and Wade were a couple before his hiring, it raises concerns about potential violation of anti-nepotism rules. Additionally, if their relationship began in 2021 as opposed to their sworn testimony claiming 2022, they could be accused of perjury. The filing notes that Mittelstadt is available to testify in court. Now, where did I hide that one? I lost a link. Well, let's see if they bring it up here. Yeah, here it is. Fulton County District Attorney response. The Fulton County District Attorney's Office is pushing back on the allegations that cell phone data suggests that the relationship between the DA and Special Prosecutor Nathan Wade started prior to the time they both testified to last week. The Fulton County DA's office filed a response, including copies of her calendar and emails late Friday to the analysis done by former President Timos blah, 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 phone records. In the response, Willis says the defense document should be rejected because it contains cell phone records that have not been admitted into evidence and an affidavit and other documents containing a qualified opinion. Willis also says that team did not provide enough written notice to the court or a summary of his purported expert's testimony. Additionally, they did not provide any information on the witness qualifications to serve as an expert witness. Blah, 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 blah. The filing also states, quote, the records do not prove in any way the content of the communications between Special Prosecutor Wade and District Attorney Willis. They do not prove that Special Prosecutor Wade was ever at any particular location or address. They do not prove that Special Prosecutor Wade and District District Attorney Willis were ever in the same place during any of the times listed in Supplemental Exhibit 38, and in fact, on multiple relevant dates and times, evidence clearly demonstrates that District Attorney Willis was elsewhere, including at work at the Fulton County District Attorney's Office and visiting the 3 crime scene where a mass murder motivated by race and gender bias had taken place. Yes, play the race card. Oh, there it is. I like it when they actually have the filings linked. I really do. Who wrote that statement? Oh, by the way, I forgot. Toddly Beep, member for 10 months. Fanny and Wade has been telling Porky. Pies, yeah. Who wrote that statement? I would assume it is... Let's see who it is. Let's go down to... Adam Abbott, Chief Deputy District Attorney, Fulton County District Attorney's Office. By the clear instruction of Miss Wade, I would assume. Now, this is interesting. This is what I wanted to show you. Defendant proposed supplemental exhibit 38, which is clearly inadmissible and has little evidentiary value, was not filed in good faith and is simply another attempt to garner media attention. Those are not, you can have both. Where was it? Well, they try to have it thrown out because not submitted in time or in the right manner and in bad faith and stuff like that. Where is it? Oh, well. Let's go back here. They have a better conclusion. Oh, not conclusion, but summary. Finally, the office is questioning whether the legal team obtained the cell phone data legally, noting a search warrant is usually required to obtain such information. We went through this. Prosecutors have a warrant. The defense can send a subpoena, and AT&T complied with the subpoena. It's not illegal, in my opinion. During last week's hearing, N.Starow told Fulton County Superior Court Judge Scott McAfee that they had obtained cell phone records that he wanted to introduce as evidence. If the new evidence from Trumpston is accepted by the court, it will most likely extend the evidentiary hearing for Roman's motion. At this time, Judge McAfee is scheduled to hear final arguments on March 1st. That is Friday. Oh, I'm going to stream that one. Let's see, what else do I have here? Let's look at this. In the Superior Court of Fulton County, State of Georgia, Supplemental Defense Exhibit 38 to the hearing on defendant's motion to dismiss and disqualify. President Trump, former president, hereby files his proposed Supplemental Defense Exhibit 38 to the hearing on defendant's motion to dismiss and disqualify. Proposed Supplemental Defense Exhibit 38 consists of an affidavit from defense investigator Charles Mittelstadt, certifying the Cellphone analysis and reports which are attached to the affidavits as Exhibits A to C. The Cellphone analysis and reports, as well as the certified AT&T records, have been provided electronically via cloud folder link contained in the courtesy service email. Mr. Mittelstadt, the author of Exhibit 38, is available to testify at the court's convenience. Let's see here. Affidavit of Charles Mittelstadt. Let's see if he is... Oh, sorry. Boom. Let's see if he is... My name is Charles Mittelstadt. I am 59 years of age. I am a criminal defense investigator working with attorneys Steve Sadow and Jennifer Little in support of the defense of Mr. Trump in that case. In conjunction with counsel of record for Michael Roman on or around February 9th, 2024, I personally served the requests for records. Yeah, they are calling it subpoena, but it is a request. He calls it a request. Upon AT&T Subpoena Compliance Center, the request documents included voice call text history as well as specialized location data for AT&T number this belonging to the subscriber Nathan Wade. Yeah, I know, Helen. I know, that's amazing. Yeah, they, as Helen says, in the first 11 months of 2021, from January to November, 12,000 text messages and 1,200 phone calls. That's not limited contact. 12,000 text messages in 11 months is a little over 1,000 texts per month. Math. Let's say 1,100. It's 1,200. Well, now 1,100 divided by 30. That is 37 text messages per day. That's not a lot for a teenager. For two people in their 50s, that's a fucking lot. That's a lot. And to that, 100 phone calls per... what was it? 1,200 phone calls. I think it was 2,000 phone calls, actually. Not 1,200. 2,000 phone calls. Close to 2,000 phone calls. I don't think I have 2,000 phone calls in total on my phone for a year. And that these two made it to it from Wade to her. This is just his phone. Well, it could be both ways, I guess. 2,000 phone calls. That is 11, I'll say 10 months. That's 200 calls a month. 200 divided by 30. Is 6 phone calls per day. That's a lot. That's a damn lot. Now, during this time, he was Miss Willis. He was the one who did the hiring to the district attorney's office. So yeah, you can explain a few phone calls by that. Only 6. There are 2,000 phone calls in an 11-month period. Oh, Jesus, math. 2,000 divided by 11 is 181. Well, 182 per month divided by 30. Yeah, 6 phone calls a day. Plus the 12,000 texts. That's a damn lot. Ghost says always text as if those text messages will be viewed and read aloud in a courtroom. Yeah. Now, if you're the district attorney and a special prosecutor, you might believe that you are untouchable. Ta-da! You weren't. Nanya Witness says, I don't say 2K words to hubby in 11 months. And hello, everybody over at Rumble. Oh, I forgot. If you prefer to have Rumble as your... let's see here. Copy. If you prefer to watch via Rumble, there it is. Dun, dun, dun. Pin message. If you want. Not necessary. Let's see. How does the poll go? What will happen in today's in-camera hearing? So far, 17% thinks judge rules privilege. 37% thinks Fani Willis storms the courthouse. And 46% believes judge rules not privilege. I think those are good odds. Oh, where was I? Sorry. On the morning of February 15, 2024, Counsel received a response from AT&T containing an encrypted link to the requested records, and I was provided access to the zip file containing the response from AT&T. Following my review of the file, I confirmed that AT&T fully complied with the request, the bulk of which included records for the period January 1st, 2021 through November 30th, 2021. The certified records from AT&T are included in the cloud folder entitled AT&T Records, which is being contemporaneously served upon all parties. Upon receipt, I began analysis using a Leeds online analytic tool called Cellhawk. Cellhawk is considered by law enforcement to be the gold standard in cell phone records and analytics. It is used throughout the United States and Georgia by law enforcement agencies and should be well known to the Fulton County District Attorney's Office. As a board-certified criminal defense investigator, having specialized in criminal cases for over 25 years, I routinely use Cellhawk to conduct analysis on records, both on initiated subpoenas and those received in discovery. My firm was granted a license and completed training in 2019. I pay an annual licensing fee. That goes to his expertise, if he can be called as an expert witness in this. And if you go back, if you go back to when I started covering the Young Thug trial in May of last year, I started with the Daubert hearings, where they check which experts the state wants to call as experts. They try to have in a person as a forensic video analyst. That person went on the stand, got questioned by the state, cross-examined by the defense. And in that cross-examination, we found out that the extent of his work for Fulton County law enforcement was that he was given a body cam film or something. He played it on his computer to the timestamp they wanted, pressed pause, took a screenshot, took that screenshot to Photoshop and enlarged the portion the cops wanted enlarged. That's it. And he has done that for over 20 years. Mr. Pinch and Zoom. That's all he does day in and day out for Georgia law enforcement. Pinch and Zoom. He was not accepted as a forensic video analyst. He was accepted as an expert on video enhancing. That's the level of expertise Miss Fani Willis wants in the Young Thug trial. And she has the nerve to say that this guy isn't an expert. Since that time, my staff and I continuously attend webinars and remain up to date on training and the latest features available via Cellphone Analytics. I have a strong working knowledge of its capabilities and limits, and I have extensive experience utilizing this program to analyze cell phone data. While I am not a cell phone tower engineer or expert, I have the equivalent experience and training of those individuals routinely tasked by law enforcement agencies or the district attorney's office with identical analysis responsibilities. Yeah. A cornerstone of the blah, 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 blah. Generating a report attaches Exhibit A, isolating all interactions. This includes voice calls and text messages between Mr. Wade and Miss Willis during the period of available records in 2021. The dates, timing, frequency, and duration of these interactions are included as part of the report. That report revealed over 2,000 voice calls and just under 12,000 text messages exchanged of the 11th month period in 2021. A heat map attached as Exhibit B highlights the interaction patterns which demonstrate a prevalence of calls made in the evening hours. Dun, dun, dun! Focusing on geolocation activity near, not giving out that address, around her apartment. Given the urgency associated with the need to analyze this newly acquired data against the relevant testimony, I constructed a very conservative geofence which isolated the 2 cell towers in closest proximity to this address. The purpose of this geofence was to conduct an initial assessment of whether Mr. Wade's phone ever connected to these towers. Additionally, this modality was used to eliminate the possibility that hits could be associated with routine travel on either I-75 or I-85 or visits to nearby attractions or the airport. Following that initial conservative sweep limited to those 2 towers, I further constrained those findings to hits on there, which pointed directly at there, at her, where she lived. Additionally, the report was limited to those occasions when the phone was connected for an extended period. This conservative analysis using the above referenced modality revealed a minimum of 35 occasions when Mr. Wade's phone connected for an extended period to either one of those towers in closest proximity to the Dogwood address based upon associated data use, voice calls, or text messages. The data reveals he is stationary and not in transit. A deeper analysis of the data would reveal additional details such as where his travel began or ended. For purposes of my analysis, I determined that his residence is located in East Cobb and was able to review the records which demonstrates his phone pinging off the associated towers near his residence for consistent periods. Because of the limitations in analyzing the sheer volume of data and preparing the report, I was directed to conduct a deeper analysis on 2 of the specific dates. Now, how did they know about these dates? I'm about to sneeze soon. Police. I would assume they already knew about these dates. In some way or another, they already knew about these dates. Sorry. Specifically on September 11, 2021, Mr. Wade's phone left the Doraville area and arrived within the geofence located on the Dogwood address. Yeah, this we already know. November 29th. So it's before and after. So the doink before and after his appointment. Probably. The findings and data are presented in a PowerPoint presentation. According to Cellphone, PowerPoint screen recordings are deemed to be the best way to present in a transparent way the totality of the data upon which the animated map feature was built. Let's see here. Cell tower analysis. No, where is it? Where's the heat map? I saw this at the lead detective. He had it. The response had the heat map. Let's see here, scrolling. Yeah. There it is. Let's see if I can make it bigger. Yeah. As you see, this looks like YouTube analytics. And it seems like most of the contacts are after office hours. Yes, cat. Spicy hours. Dun dun dun. I mean, circumstantial, but very, very, very telling. Very, very, very telling. Very, 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 very telling. Let's see, what else do I have that we can... Dun dun dun. Let's see what else I have here. I feel like I am What am I missing in what happened last week? There is something I said he did the day before he was appointed. He only had $2,000 in his accounts. And 18 months later, he had invoices for over $500,000. I did that. What else do I have? Help me, chat. What have I missed? What have I missed? Dun, dun, dun. Phone records, we did that. Well, that's not a bad guess, because Miss Willis did Mr. Wade an interest in favor in her testimony when they asked about Mr. Willis' illness, when she claimed that I will not emasculate a black man, blah, blah, blah. And yeah, there's only one type of cancer in a man that can be interpreted as being emasculated. So I'm betting Mr. Wade is very thankful for Miss Willis to get that out to the general population, that he literally has no balls. Now, that I can't imagine that. It can't be easy. But don't do stupid things like boning your boss. Might have been a good idea when this started, when they knew they were on to them, to just let's tip it toe out of here. Okay, I will recuse myself for the public good, or something stupid. No. Yeah, I know you can still have a boner without balls. Yeah, I know. Oh yeah, Mr. Wade's divorce, by the way, is still ongoing. It was said they settled out of court, but they are still doing the negotiations. More or less, how much does Mr. Wade actually have left of his money, and how much of that is he going to pay his soon-to-be ex-wife and the kids? I would assume, since he spent a majority of that on Miss Willis, that his soon-to-be ex-wife wants everything that's left, because he was appointed and the day after he filed for divorce. That's about, yeah. Let's have this up. Yeah, we are waiting for the cover. Oh, let's see here. Okay, now we are waiting for Young Thug, which means I am going to change the thumbnail for this stream. So we are going directly over to the Young Thug trial. And if you're only interested in the Fani Willis, this might be important to you as well, because this case shows the absolute cluster F that is the state's case. and what to expect if the former president RICO case ever reaches trial. How incredibly bad prosecution can be. That is Mr. Williams, also known as Young Thug. Hold on while I put up Mr. Jingles. If you haven't met Mr. Jingles yet, Mr. Jingles is my farm cat. He is a rescue cat, and he has been plotting to kill me the past 7 years. No, I didn't. Thank you. No reply. Did you go with Fani Willis submitting the wrong dates for a file against the cell data? Yeah. The cell data for those 2 days. When she filed her reply, she filed the wrong date. So instead of September 11th, she submitted her calendar for September 9th and 10th, not the 11th. Same with the November 30th. She submitted the wrong date. And that, my dear friends, is... And coincidentally, you can have a mug like this yourself. It's in my merch store, together with my Sixth Amendment collection. With if you have a friend or family that sometimes are in cahoots with the law and they keep talking to the police, you can get them a doormat that says, "I invoke my Sixth Amendment rights." Because sometimes people need a reminder that they actually have rights. Kitty is right over there. Well, I'm not pointing to that. He is asleep over there. Should I throw something at him? No. Yeah, so we are awaiting the Young Thug RICO trial now. And oh, you're in for a treat. If you haven't seen any of this before, you are in for a treat. As I said earlier, prosecution, 771 witnesses on the witness list. Most of the cases in this trial under the RICO Act are crimes that the majority are cases where the charges was dropped, but they are still in this trial as underlying acts. Mr. Nichols, the man, let's see here, Mr. Nichols, who is, hold on, I will show. Mr. Nichols, I think that's, no. Well, one of the defendants in this trial is mentioned once in a trial where the RICO charge has 196 underlying acts. Latest filing from Trump's attorney in response for the DS motion to have the cell phone data excluded. This was done late yesterday. Why there will be breaks in this trial, and I mean, while we are watching the trial, it will start soon because camera is on. Sometimes the judge is late, and when I say sometimes, the judge has never been on time one day for 2.5 months. He has been 20 minutes late up to 90 minutes late, because in the 90-minute late, he had a meeting with the legislator. Because apparently a politician wanting to have coffee is more important than keeping this trial going. will search for that. Response to tools anytime past 24 hours. There. Yeah, I'm having that on, so I will hear when it starts. So let's have this up. State blah blah blah. President's reply to state's response to Supplemental Defense Exhibit 38, CSLI evidence. Affiant Mittelstadt is not being offered as an expert witness, so neither the court standing discovery order nor Daubert applies. Okay. The state protests that the defense is somehow not entitled to present expert testimony regarding the cell site's location information, as they allege that the defense failed to comply with this court standing discovery order that mandates prior notice to the opposing party of a party's intention to introduce expert testimony, and because they claim that the defense has not pre-cleared the evidence through the process of a Daubert hearing. However, neither of those preconditions apply here, because the CSLI information that the defense intends to introduce through the testimony of Mittelstadt is not being offered through expert testimony, and Mittelstadt will not be offering any opinion testimony. He will be summarizing the data that was produced by AT&T in response to the lawfully issued subpoena, as well as factual information that he acquired regarding cell site locations. First, the 11th Circuit has held that precisely the type of evidence that Mittelstadt will offer does not require the testimony of an expert witness. In Ransford, the case, the government presented a witness from the Cellphone service provider who explained how cell towers work and how evidence preserved in the company's computers can show that a tower cell phone was pinging at a certain time. A police detective also testified how cell phones ping off towers. The Ransford court explained why the company's witness was permitted to offer testimony that was neither expert testimony nor opinion testimony about the cell towers and location of the phones. And here's the quote. The holding in Ransford dictates the result in this case. Questions about the interpretation of Georgia Evidence Code rely on 11th Circuit precedents, absent any contrary authority from the Georgia appellate courts. There is no contrary authority from any Georgia appellate court. Yeah, the Judge Glanville, has a service dog named Jack behind his desk. And that is because Judge Glanville has PTSD from his service in Afghanistan. Second, there is clear authority that cell tower evidence linking a particular phone with a particular cell tower at a particular time can be established through the cell phone records without any witness testifying. The 11th Circuit approved the use of the business record exception to admit cell phone tower records that documented the tower nearest to the cell phone when a phone call was placed by that phone. All right, we will continue with the Fani Willis saga in breaks in this trial. Thank you for staying. We are a few people down since the peak, but more than I normally have here.
All right, ladies and gentlemen, please be seated. Thank you, Sergeant Ingram. All right. Members of the jury, good morning.
Good morning.
All right, y'all sound good. Still the caffeine's still running in core sensory. That's a good thing. All right, ladies and gentlemen, we're going to continue with the examination of our witness that we had on the stand on Friday. So, retired Detective Velazquez, you are still under oath, sir. Okay?
Understand.
All right, thank you, sir.
Thank you, Your Honor. Detective Velazquez, last couple of questions I have for you. On Friday, you identified State's Exhibit 151, 152, 153, 154, and 155 as items collected from the scene. Handing you State's Exhibit 151, 153.
Yeah. Let's see what this
154 and
is.
155. Are these all pieces of the car that were collected from the scene?
154C is a piece of the vehicle from the detective's vehicle. 151C, also a piece of the detective's vehicle.
Yeah. First, have me explain here. This is retired officer Vincent Velazquez. He is introducing evidence regarding an alleged crime committed in 2013. Yes, in the Young Thug RICO trial, they have cases from 2013 as underlying acts. They can have that because the statute of limitations are null and void, since one of the underlying acts is a murder case. So any misdemeanor, anything, can come in this RICO trial as evidence of the YSL being a criminal enterprise.
.155C, also a piece of the detective's vehicle. And 153C, also a piece of the detective's vehicle.
And 152, Charlie, are these the shell cases that were collected?
May I look inside? Yes, they are.
Thank you. As part of your duties with OIS team that day, did you also interview persons at the request of lead detective Velazquez? I'm playing.
I did.
Thank you. That's all I have for now.
Thank you.
Cross.
All right, here. The interesting part in this trial is always the cross-examination. Mr. Steele is attorney for Jeffrey Williams, also known as Young Thug. He's an expensive lawyer, and it shows. He is, in my opinion, brilliant at cross-examination.
Good morning, sir.
Good morning, sir.
Sorry. You, if I heard you correctly, you worked with APD, Atlanta Police Department, for 22 years, or was it more than that?
22.
You left the Atlanta Police Department in...
Okay, this is not Mr. Steele. This is the attorney for one of the other defendants. I keep forgetting his name.
What year?
2017.
Did you work in the Fulton County DA's office for some period of time?
I did.
Investigator?
I was assigned to the DA's office, yes.
You were assigned to the DA's office from
2004 until, I believe, 2009. I was multi-agency cold case squad.
Okay, so what that means, well, tell me, if what that means is that you're an APD officer, but you're assigned to work with the Fulton County DA's office for a specific purpose.
That was correct, yes.
Cold case squad, is that what that was?
Yes.
Is it? It is not one. It is not one. All right, thank you, ma'am. Let me jump into that a little bit. You are familiar with with Zone 3, correct?
Yes, sir.
You're familiar with Zone 3 and specifically the Cleveland Avenue corridor, based on your years as a police officer,
I am.
based on the work that you've done in that area.
Yes.
You were asked last week, and I believe you testified, that over the period of time that you worked in that area, you spoke to numerous people in the Zone 3. And I'm gonna kind of confine it to Cleveland Avenue corridor, in that corridor. Is that true?
Yes.
Okay. People who lived there, who were residents, right?
Correct.
People who were witnesses for different offenses or different crimes or different things you were investigating, right?
Yes,
You've arrested numerous people in that area, correct?
I have.
You worked with, did I hear you say that you worked with the Red Dog Squad at some point?
I did.
Okay, how long were you a Red Dog officer?
2.5 years.
Okay, during that period of time, now is Red Dog primarily focused on drug-related offenses?
Drugs and, well, all levels of street crime, drugs, weapons, things of that nature.
During the period of time that you worked as a Red Dog officer, you had occasion to arrest a number of people in the Cleveland Avenue corridor.
That's an accurate representation.
inaccurate?
That is accurate.
Okay.
Yes.
You would serve search warrants.
We did.
You would serve arrest warrants, arrest people, right?
We did.
You became familiar with what the general trends and the crimes and so forth were in that area. Is that fair to say?
During that time, yes.
Yes. And in fact, during your entire period of time as an Atlanta Police Department officer, you would say that area is a high crime area.
In Zone 3, in particular, the Cleveland Avenue area of Zone 3.
But let's say Zone 3 first.
I would say it is one of the 6 zones that have an increased level of crime, yes.
Okay. And specifically the Cleveland Avenue corridor, very high crime area.
It would be difficult for me to characterize the Cleveland Avenue area as having more crime than another particular area. I think that would require me to do some analysis.
Okay.
So I wasn't prepared for that. So I don't know if I can testify to that.
This is him evading because he testified last week about the years he spent in those specific areas. So he should be more than qualified to have an opinion. But the defense is going here for this is generally a high crime area, not depending on the supposed YSL gang. That is what they're going for.
Well, let me just ask you about your experience.
Certainly.
Would it be fair to say that you have investigated numerous murders in the Cleveland Avenue corridor?
Objection as to vague numerous.
I sustain the objection.
All right. You have investigated murders in the Cleveland Avenue area.
Yes,
More than one,
I have.
more than 10.
I don't know. And to be quite honest with you, from being in homicide for 17 years, it's difficult for me to think about, I probably could come up with that analysis, but as I sit here today, it would take some time for me to really go back and think about that.
This person had an impeccable memory regarding what the state asked him. Now, he is a state witness, and they went through it. But he is there to testify as a police officer as well. He should be neutral regarding the evidence of that area. But all of a sudden, memory loss.
I have personally handled homicides
Yes.
in zone 1 through
I need to fetch
6.
something to drink.
So I
I'll
can't
be
tell
right
you
back.
if that Cleveland Avenue area or zone 3 was significantly more than zone 1 or zone 4.
All right. When you were asked last week to talk about that area and what you knew about the area, I think I heard you describe it as it's an area where people are trying to get by. All right.
I did say that.
It is a poor area. Was that fair to say?
I think it's economically depressed, yes.
I mean, it was part of the Atlanta empowerment zone, wasn't it?
I don't know.
Okay. It is an area that has about 30% employment. Isn't that about right?
I
You know
don't
that,
know.
PK?
I don't know the employment statistics of zone 3.
Okay. There are a lot of drug crimes that go on in that area.
Objection as to vague.
There are drug crimes that go on in that area, correct?
Go ahead.
I'm sorry, Judge.
That's all right.
True?
I have personally, while working Red Dog, arrested a good amount of people in zone 3 for drug possession, yes. In the 90s, specifically.
There are, in the 90s, would that be the main period of time that you worked on the street, for lack of a better phrase?
Yes,
Zone 3?
specifically from 1997, mid-1997 to November of 2000.
Okay. Would it be fair to say that if you are a child or a juvenile growing up in that area, you're growing up in a pretty rough area?
Objection, speculation, and vague.
Oh, I'll stand.
Okay. Based on the time that you spent in that area, did you have occasion to interact with the people who lived in that area, including young folks?
I did.
Okay. Would you say, based on your interaction and your observations, that growing up as a young person in that area appeared to be a difficult endeavor?
Objection, that is ambiguous, vague.
Oh, with objection.
I don't have an answer for that. I think that would require me to put forth a robust analysis. I'm not prepared to testify to that right now.
All right. Based on your observation, and I think the number that I wrote down that you said was that, let me get it right, that you probably had occasion to visit more than 150 homes in the Cleveland Avenue area during your time as a police officer. Is that about right?
I think I may have testified in zone 3, not
3.
specifically Cleveland Avenue, yes.
Okay. Would it be fair to say that from your observation, your experience, that people who live in that area are working hard, trying to get out of poverty, trying to get out of that area? Is that fair to say?
Objection, compound question.
Stand the question.
Yeah, this is something the defense have been going for a lot, that the Cleveland area in Atlanta is extremely stricken by poverty. And for decades, the politicians of Atlanta had done very little. The whirl of doom.
You had occasion to, have you had occasion during a period of time that you interact with the folks in Zone 3 to come across young folks who were trying to find any way to make it in that area?
I think my experience has been overall, if we're specifically talking about young folks, I think I've experienced more young folks who are making it in a relative sense of living in a neighborhood, going to school, doing what they were supposed to do. My recollection of knocking on doors and talking to people, witnesses and families, many of the children that I either spoke to or observed were like any other kids that I've experienced in my life, personally and professionally.
Wanting to do better, right?
I think generally speaking, everyone wants to do better.
Sure.
I don't know that that's specific to Zone 3.
Right, but coming up in an area that you've described, that we've been talking about, where there's a significant amount of crime, right?
Objection, Your Honor, with a significant amount.
Where there's crime, all right, it's a tough area, right? Is that fair to say?
Overall, Zone 3, I think, I don't know if I can say Zone 3 itself is a tough area. I think there are pockets in Zone 3 that are a little more challenging than others.
Okay. It'll be challenging to come up there as a youngster. Would you agree with that?
I think my analysis is more so based on crime. There are some pockets of crime in Zone 3 that are a little more prevalent than other areas of Zone 3.
And if you live in that area, you are, well, for lack of a better word, in the middle of those pockets of crime. Is that fair to say?
Objection, Your Honor, that's fair.
All right. So let me ask you a little bit about your role as an investigator, and specifically this investigation. In this case, Detective Quinn was the lead investigator in regards to this incident.
That's correct.
And when I say this incident, we're talking about this incident that occurred on September the 11th of 2013. Fair?
Fair.
Okay. This was an incident, as you know it to be, based on your involvement, of a shooting that occurred in the Summerdale Commons apartment complex, right?
Yes.
Followed by the discharge or the shooting of a weapon by a police officer, Robeson L., right?
Correct.
The shooting of two individuals identified in a car, a maroon car, right?
Correct.
And a car crashing into a laundromat, and individuals getting out of that car, right?
Correct.
All right. Now, 22 years on the force, Red Dog, working with the DA's office, you understand, and certainly you did then, the need for a thorough investigation, right?
Yes.
You want to do a thorough investigation anytime you're involved in one because there are important things at stake. For example, whether a person who has committed a crime is apprehended or not. True?
Your Honor, I'm going to object to that as a compound question.
I'll sustain this one. You can break it up.
Sure, I'll break it down. You want to do a thorough investigation because if someone has committed a crime, you want to try as best you can to apprehend the person who has committed that crime. Is that true?
I would agree. I would agree.
Okay. You would want to identify someone who has committed a crime versus someone who has not committed a crime. Is that fair to say?
Objection, Your Honor, vague. Because they may have to identify witnesses.
All right, break down even more, all right, for everyone. In this case, you knew as part of your investigation that there were allegedly multiple individuals who came out of a vehicle. Is that fair to say?
I did learn that later, yes.
All right, as part of your investigation, right?
Correct.
Okay. In investigating a case, one of the things you might want to do would be to take statements from witnesses. Is that true?
I would agree.
Right. And as a police officer, you take a statement from a witness to get as accurate an account of what that witness saw as possible. True?
I would agree.
All right. You would want to hear from that particular witness in their own words what they knew or what they experienced. True?
That's what taking a statement entails, yes.
Right. And if you are a police officer or an investigator taking a statement from a witness, you don't tell them what happened. You listen to them tell you what happened. Is that true?
That's too vague
How is that? I'm sorry.
and compound.
I'll sustain this to compound.
Okay. If you as a police officer or investigator are interviewing a witness, you would not want to tell that witness what they saw, would you?
No.
You would want to have that witness tell you what they saw, correct?
Correct.
And you're stuck, I mean, whatever they tell you, it is what it is, right?
Not necessarily, no.
Okay, well, I mean, if a witness tells you something and you are recording that statement,
Your Honor, I'm going to object as to
Basis.
speculation. If the witness
He's a police officer or a retired police officer. He should be able to answer questions about standard procedures. Here's the thing, the prosecution objects because the recording of the alleged crime is gone. There might have been a recording at some point in time, but now it's gone. Conveniently.
throw something in the report.
That's saying this is speculation.
Okay. When witnesses give statements, sometimes you record those statements, right?
Sometimes.
All right. And you talked in your
Hey,
in your
Mrs.
direct
Gregory.
examination when the prosecutor asked you some questions about policy and procedure. You talked about the need to observe proper police policy, right?
Right.
It is not proper police policy to erase the statement of a witness and then tell them, now let's start over, right?
Oh, sorry, I forgot. The police officer who interviewed one of the witnesses, whose car was lent or stolen and then found on another place. That was last week. The officer wasn't satisfied with the answer he got. So he deleted every statement until he got the answer he wanted. There are so many cases during these 2.5 months, so they start to blur together. But now when the lawyer asked the question, that's what it was. Yeah, so the officer on site interviewed people, and if they didn't give him the answers he wanted, he erased and erased and erased again, over and over again, until he got the right answer. And that is the recording he saved.
An official statement, and I think in context, erasing what context?
If a witness gives you a statement and you record that statement,
Your Honor, objection as to speculation.
I stand the objection.
is it police policy to record a statement from a witness and then erase the statement?
There is no policy that exists that specifically addresses that.
Okay. Is that proper protocol?
It could be.
Okay.
People, and I think in context,
Seriously? This former cop sits on the stand and defends the procedure of erasing witness testimony, witness statements, until you get the right answer. Jesus Christ.
typically interviewing witnesses and sometimes even suspects, more often than not, they lie. Many.
And that's why it's important to keep all the recordings. So you later on can say, hey, look at this. He started out with that statement, changed his mind, changed his mind, changed his mind. Then you can prove a pattern of lying. So if that person then shows up in court as a witness or a defendant and takes the stand and tells a completely different story, you can impeach him. As Heather Moshe says, that's why you don't delete anything, sir. Yeah.
Times witnesses have told lies.
Okay.
And we, doing this job long enough, understand when we start to see that developing.
All right, but
I wasn't done. I wasn't finished, sir.
go ahead, finish for me.
So in that context, when one is taking a statement, if you choose to record that and it is, in your opinion, complete fabrication, it doesn't line up with the facts, we could stop the tape and re-record it.
Okay.
Once we start presenting facts or challenging that witness or suspect, and then they, I hate to use this word, but a come to Jesus meeting where we're like, okay, this is a lie. You know, you lied. Let's get down to the nitty gritty now.
Is it your role to make a determination as to when someone's lying or not?
Objection, Your Honor, as to vagueness.
Oh.
In what context?
I stand.
In the course of a police investigation, right? If a witness gives you a statement, right, is it your role to determine what statement is true and what statement is not true?
Your Honor, this is speculation.
I stand the question.
When you record statements, is one of the reasons that you're recording the statements for purposes of perhaps passing that information on to, let's say, a prosecutor's office later on?
Yes,
When you record a statement as an investigator, is part of the reason that you're recording the statement so that you can later on go back and look at or listen to what a witness said.
that's part of it, yes.
When you record a statement, is one of the reasons that you record a statement so that you can compare that witness's statement against other witnesses' statements?
That would be corroboration, yes.
Right. And so if a witness gives you a statement and you erase it, you no longer have that statement that was given previously, is that right?
I'm sorry.
I'm trying to finish my question.
Yeah, I know, I followed your questions. I apologize. I object as to speculation.
I stand the question.
And the judge says,
In this case, are you aware of any statements that were taken and then subsequently erased?
No,
You testified earlier about, and you were showing photographs of the debris from the vehicle in the Summerdale Commons Apartments. Remember that?
I do.
Okay. Did you also go to the location of the laundromat where the car had collided with the wall of the laundromat? Did you go there?
I did.
All right. Did you have occasion to either search for or to retrieve any video surveillance from that laundromat?
No, I just merely drove there. I don't even think I got out of the car.
Okay. You didn't speak to anyone at that location?
Not at all.
Okay. Are you aware of whether any video surveillance was recovered from that laundromat?
I'm not aware.
Okay.
Whether it was or was not, I don't know.
Who would have been, if you know, who would have been
Visa Martikainen asked, is there evidence that the recordings were actually erased? Yes. It was testified to on by one of the previous cops that he believed that the person was lying to him, so he erased because he kept the witness kept changing the story, and when the officer felt that now you're telling the truth, I would keep that recording.
responsible for retrieving any video surveillance from the laundromat if there was any?
Objection, Your Honor.
He's the investigator, Judge.
I stand the objection now.
Do you know if a crime scene person or anyone else involved in the investigation sought or received video surveillance from the laundromat?
Your Honor, I'm going to object asking it.
I'll allow that one.
I do not know.
Did you seek or obtain any video surveillance from the apartment complex?
There was none.
Okay. And whom did you check with in regards to that?
The manager. And also my observation of the buildings not having cameras.
Okay, so there are no surveillance cameras at any of the buildings at that location?
That was my interpretation from what she said in my observations, yes.
That's a weird wording. Let's listen to that again.
So there are no surveillance cameras at any of the buildings at that location?
That was my interpretation from what she said in my observations, yes.
That was my interpretation of what she said. What? That's weird.
You testified earlier about radio traffic and communicating with, was it Investigator Quinn that you communicated with over the radio while you were at the crime scene?
I don't believe that's what I testified to, but I could have.
Okay,
It wouldn't be uncommon for me, he and I, to communicate over the radio.
okay. Did you testify previously that there was someone that you were talking to on the radio where you had to switch channel to talk to someone?
I think my testimony was not specifically me communicating with someone. It was generally speaking of what happens in a chaotic scene like that, where the dispatcher requests all the units on the scene to switch to what's called a TAC channel.
Okay. Were you monitoring the radio traffic during the investigation? And obviously you arrived after the fact. So were you monitoring the radio traffic afterwards?
I think so. For clarity,
When you were at the scene?
so there's several channels that are involved here. You have Zone 3, Detective Radio, and TAC. So specifically, which
Any?
I was probably still on Detective Radio. I just don't specifically recall.
Okay.
And then when the dispatcher advises people to go to TAC, I likely switched over to the TAC channel as well.
Okay. Were you involved in looking for any suspects on that day?
No,
Okay. Were you involved in assigning anyone to look for any suspects on that day?
I was not.
Were you involved in taking any descriptions of possible suspects on that day?
I did take 2 statements from 2 of the officers involved. I don't recall in my
I
questioning.
would object to any testimony that is hearsay from anyone not.
I've not asked for any hearsay testimony, Your Honor. The question was whether or not he, or a specific question did not call for hearsay. Actually, I'll ask the question again.
Wait a second.
Yeah.
Yes. Were you?
Yeah, you can answer that.
Can you answer
Yeah.
the question
Were
again?
you involved in taking any descriptions of potential suspects on that day?
Again, I could have. I took 2 statements from 2 officers. I don't recall whether I specifically asked them to give me those descriptions. I may have. I'd have to read their statements.
Okay. Did you have any interaction with the individuals who were arrested by Officer Black, Officer Davis?
No,
Okay. Were those individuals gone by the time you arrived at that location?
I don't recall seeing any suspects, so I would assume yes.
Was there a point where Detective Lewis, you know who Detective Lewis is?
I'm not familiar with Detective Lewis.
Was there a Detective Lewis involved in this investigation on this day that you recall?
Not that I recall.
Do you recall receiving any photographs of someone named Adrian Bean?
I'm sorry, I do recall. My memory is reflected. Tracy Lewis. Detective Lewis did send me a photograph of Adrian Bean.
Okay. What did you do with that photograph of Adrian Bean?
I believe I sent it to Detective Quinn either via email or text.
Okay. You did not have any interaction personally with Adrian Bean, is that correct?
No,
Did you understand him to be someone who was in the vehicle that was at issue in this case?
Yeah, I'm going to object, that will call.
Sustained objection.
All right. Let's go back a little bit and talk about the evidence that was shown to you by the state last week. You were aware that this red burgundy-ish vehicle was part of this incident, correct? The one that went into the laundromat, correct?
Yes.
All right. Now, tell me if you were aware of whether there were any fingerprints retrieved from that vehicle.
I don't know.
Do you know whether or not there were any hair or fibers retrieved from that vehicle?
I don't know. I wasn't involved in that part of the investigation.
The bullet defects that you were shown last week, remember you were showing a photo?
Oh yeah, forgot to say that. The persons arrested are not one of the defendants in the 2013 car crashing into a laundromat. This is an underlying act in the Georgia RICO Act. They can use this because they allege that the people they arrested are associated with YSL. That's how vague and broad the Georgia RICO Act is.
Graph of, when I said bullet defect, a hole in the window in building 300, I think.
Yes, sir.
Where a bullet is going through. Was the bullet defect or the bullet itself actually retrieved from the wall inside of that apartment?
It was not.
Were you or anyone else able to determine which gun or what gun fired the bullet that went through that window?
No.
We know, though, and you know as part of your investigation, that Detective and Investigator Officer Robeson L. actually discharged his weapon a number of times. Is that correct?
Correct.
In fact, there were shell casings that were found there at the location that came from his gun. Is that right? Or do you know that?
I don't know conclusively. I've not read the crime lab report. It's assumed they were the same caliber, same make and manufacturer as the ammunition that we carry.
Okay. The vehicle that was shown last week, the one that had the broken out rear window, right? Was there a bullet fragment or bullet or anything found inside of the vehicle that actually made that broke the window? Was a bullet retrieved?
I wasn't involved in that part of the investigation. I don't know.
Would it be fair to say that you don't know, we don't know what bullet actually broke that window?
Your Honor, I want to object to that call for speculation.
Do you know?
Still calls for speculation.
Remember to hit that thumbs up. It helps the channel. Thank you.
Was that vehicle with the broken window located in the same area where Officer Robeson L. discharged his firearm?
Your Honor, I'm going to object because that would call for hearsay.
If he knows, Your Honor.
No, I'll objection. If he knows.
If you're referring to the red vehicle involving the incident,
No,
I'm sorry.
no, the one that had the broken out rear window. I guess it was a silver vehicle. I'll tell you what type of vehicle.
Suburban.
Suburban. Was it a Suburban or a Tahoe?
Or the SUV.
Right. You know what I'm talking about.
I understand which vehicle you're
Right.
speaking. Can you ask the question again, please?
Yeah. Was that vehicle located in the same area where Officer Robeson discharged his firearm?
It was located in the same apartment complex, and I think area is a vague term. I'm not sure what you mean by area.
Well, do you know?
Proximity of where shell casings were was not far from
Okay.
there.
Mr. Jingles is here.
So do you know where it was Officer Robeson was when he discharged his firearm?
And Your Honor, that would call for hearsay.
This is the Young Thug trial.
He wasn't.
And what does that has to do with Fani Willis? Fani Willis is the district attorney in Fulton County, and this is a Fulton County RICO trial. So she is the one who set all of this in motion. So it can be interesting for you who only want to know more about Fani Willis, is what kind of trials she once had instead of clearing the docket of 20,000 cases that are awaiting trial.
Do you know where the shell casing from Officer Robeson L's gun was located in the complex?
I object, Your Honor. That would call for speculation.
That's based on his observation, Your Honor.
Yes, I'm a same judge.
Did you see the shell case, a 40 caliber shell casing?
I located 3.
Okay, where were they located?
Can I refer to my report?
Absolutely.
Hello, Fanfais. Welcome.
So my report, as I listed the evidence marker 3, 4, and 5 are the shell cases, the 40 caliber shell casings.
Okay.
And when you are measuring evidence, you pick 2 points of reference, point A and point B, to triangulate the evidence. Point A, just for the purpose of measurements, was the southwest corner of building 100. Point B is the southeast corner of building 100. So do you want me to actually give the measurements, or?
No, I don't need the measurements.
Oh, that's the only thing I can testify to.
Okay, you know generally where they were located in the apartment complex. Is that fair to say?
I do, according to my measurements, yes.
Okay, and so knowing where those shell casings were located, and do you know where the vehicle, the SUV, was located that had the rear window shot out?
Yes.
Okay. Were those shell casings in close proximity to that vehicle?
Your Honor, I would object it to vague. Make it close.
Give us, if you would, don't say close or far or around, just give us the measurement, the distance from the shell casings to the vehicle.
There is no measurement. So we don't measure. The measurement is for the evidence location, but based on my diagram, I can testify the vehicle was by the front gate leasing office, and shell case, the casings, evidence marker 3, 4, and 5, 40 caliber shell casings were just across the entrance gate. And just thinking back, I'm looking at the photographs, I would estimate probably 50 feet.
50 feet.
Give or take.
Thank you.
So it could have been friendly fire.
Did you have, you did not have any interaction with someone by the name of Walter Murphy on that day, did you?
No, sir.
Were you involved in the decision to issue any charges or taking out any warrants against anyone by the name of Walter Murphy?
I was not.
Were you at any time after this day, September 11th of 2013, called upon to testify in any form of fashion in any case involving a Walter Murphy?
I was not.
Oh, Mr. Jingles is going to kill me one of these days.
So,
yeah, Ghost 3. The triangulation involves 3 points technical based upon the prefix 3, former math teacher says. Yeah, if you have a window shot over there and the casings over there, you can calculate, okay, where, and you know approximately how far casings travel from the gun. You can, within a couple of feet or yards at least, say where did those shots originate. So they can. if they won't at least come close to knowing who actually fired that one.
If I hear your testimony correctly, you went to the location on that day, true?
I did.
You you drew the legend that kind of made reference to where the different items of evidence were, correct?
I did.
You drove to the laundromat, true?
Yes.
You did not interview anyone arrested in this case, correct?
Correct.
You were not the lead investigator.
I was not.
You spoke to 2 officers, correct?
I took statements from 2 officers.
Okay. Was Officer Porter, Bridget Porter, one of those people?
Yes.
Okay. Without telling us what she said, were you able to get a written statement or a statement, I don't know if it was written or not, from Officer Porter?
Yes.
Was it your understanding from investigating this case and talking to her that she was a witness to a portion of this incident? Your Honor, go.
He's an investigator taking statements.
To his investigation, if he did you talk to Officer Porter because you believe
Objection.
that she was a witness to this case and was necessary in your investigation?
I'm gonna sustain the question. It's compounded.
Okay. Did you believe, based on your investigation, that Officer Porter was a witness in this case?
Objection, Your Honor.
Oh, objection, you can answer it.
Yes.
All right. And was that the reason that you spoke to her?
Yes.
And was that the reason that you took a statement from her?
Yes.
And as we discussed before, when you take statements, those statements may later on be passed on to the prosecuting authority, like the DA's office, right?
Correct.
So that they would have the information that you garnered from that witness, correct?
Yes.
Okay. Any reason to believe that wasn't done in this case?
What wasn't done?
That the information in regards to Officer Porter wasn't passed on?
I don't have any reason to believe it wasn't, no.
Okay.
Where's that statement?
Did you leave, I mean, have I properly summarized essentially what you did in regards to this case, or was there something else that you did?
Object as to testimony regarding property summarized. He's testifying.
sustain the objection.
All right. The question I asked you before about the things that you did, going to the location, going to the laundromat, are those the things that you did on that day?
Yes.
All right. Did you at some point leave the scene?
Yes.
Did you have any further involvement in the case after that?
Taking 2 statements back at homicide, yes.
Okay. And after that, anything else?
No.
Okay. One moment, please.
Yes, sir.
I agree with Heather Mosher here. But defense should complain to the judge about absurd objections. The prosecution objects because they know they have a good chance of having those sustained. And Heather Mosher further says, and the judge needs to stop misinterpreting the law on the objections. Testifying to your job responsibilities is not speculation. I completely agree. Welcome to the Young Thug trial. We who have seen this entire trial, this is what's going on. The judge sustains objections for the prosecution roughly 80% of the time, maybe even 90% of the time, even though the objections sometimes are completely absurd.
Detective, you weren't the first officer on the scene, right?
Which scene?
On the, well, investigator, the whether we're talking about the apartment complex or the laundromat. You weren't the first officer there.
No, sir.
By the time you got there, other officers were already there,
Yes.
uniformed officers,
Yes.
any other detectives there? And I'm using, APD does it a little differently. I'm using the term investigator and detective interchangeably. Any other investigators or detectives there?
I don't recall.
Okay. Did you say that you met investigator Quinn out of the location?
I believe Quinn came out. Honestly, I remember talking to Quinn, whether it was at the primary shooting location or when I drove to the secondary location. I don't recall which one.
Okay, but your recollection is that he was there at either one of those two locations?
One of the two that I personally spoke to him.
Okay. Do you remember approximately how many officers were out there?
At the shooting location?
Yes.
Maybe 4 or 5 when I arrived.
What about over at the laundromat?
I don't recall. I was literally there for maybe a minute, 2 minutes.
Okay.
But my recollection is when I got there, I was asked to go to the office to meet with the 2 officers to take statements.
Okay. They had already been removed from the scene?
I don't recall seeing them, so I don't know.
Okay.
They could have been there. I just don't remember seeing them.
Okay. So about 4 or 5 officers over at the shooting scene in the apartment complex, and you're not quite sure about how many over at the laundromat?
I have no idea. I didn't get out of my car.
Okay. Did Detective Quinn stay there at the location after you left?
I don't know.
Okay. You would not have been in a position to assign him to do anything because he was the lead detective, right?
That's correct.
Okay. All right. That's all.
Any further examination? Yeah, Mr. App, go ahead.
Thank you, Your Honor. Good morning,
Morning.
Detective Velazquez. How are you?
Great. Thank you.
We've met before, right?
Several times.
Yes. Your investigation in this case did not involve in any way Mr. Diamante Kendrick, did it?
Don't know the name.
Don't know the name?
No, sir.
Do you know this man sitting in the white sweater next to me?
I do not.
Okay, thank you. No other questions.
Anybody else? Mr. Matthews, Senior, go ahead, sir.
Good afternoon, Investigator Velazquez.
Good afternoon.
A few questions for you. Zone 3 is an area that you patrolled and investigated numerous crimes in that area, correct?
I did.
Can you tell the jury if Jonesboro South Apartments is located or was located in Zone 3?
It was.
Can you tell the jury a little bit about what you recall in terms of your investigations of did you conduct any investigations in Jonesboro South Apartments?
I've had both through Red Dog and Homicide, several.
Tell the jury what was Jonesboro South Apartments?
Jonesboro South was a housing complex on Jonesboro Road. It was a gated community, townhouse type apartments. They had a good number of, over the years, a good number of homicides and a good amount of crime that occurred inside the complex.
Would you, to the best of your knowledge and belief, how many murders did you investigate in Jonesboro South Apartments?
My recollection, personally, 2 that I can recall in my 17 years.
How about drug crimes?
In the 90s, I think maybe 3 or 4 arrests I personally made in Jonesboro South.
Was Jonesboro South a subsidized housing community?
It was part of the Atlanta Housing Authority.
And when you investigated drugs and murders in Jonesboro South Apartments, did you have an occasion to talk to members out there in the community?
I did.
Did those members in the community talk back to you and give you helpful information?
Yes, often.
Were there ones that did not?
There were some residents who were not helpful.
Would you agree that Jonesboro South Apartments was a lower income community?
Yes.
Would you agree that many of the residents out in Jonesboro South were at the poverty level?
I think based on it being a housing property, Subsidized housing, yes.
Okay. Now, you were investigator for 17 years, I think you indicated.
Yes, sir.
During those 17 years of investigating crimes, did you have an occasion to interview witnesses?
I did.
Did you have an occasion to get statements from those witnesses?
Yes.
Did you, during the course of your investigations, did you start an interview with a person and record it and then erase the recording?
I've done that.
How many times have you done that?
Objection, Your Honor. Relevance.
Goes to credibility, Your Honor.
Objection.
I'll allow it.
Thank you, Your Honor.
I don't know. As I testified before, in context, many times I would have a tape recorder just running in my lapel, in my pocket, and knocking on doors. And again, as I'm interviewing someone or witnesses, especially, they would lie. I would have facts or have a feeling, even not even knowing. And
You felt they were lying, so you erased recordings because you felt they were lying? What if the facts you thought you had turned out to be wrong? All of a sudden, the recording you saved was wrong because you decided on your own that this piece of evidence, nobody needs to hear about it ever again. Even though you might have been wrong on the facts and they were right in their testimony. So they started to change their testimony to please you. And this seems to have been the conduct in the Atlanta Police Department. Holy fuck. Are you kidding me? This is evidence tampering. Here's the thing. If you don't save the original statements, how can you impeach the witness later on? By your testimony? That's not how it's supposed to work. This is, yeah. And the thing is, I'm not even surprised. Because throughout the trial, most police witnesses have been less than credible, in my opinion. Most. This is insane.
then through the conversation, start over and say, okay, an official statement, and then speak on the official statement that what you told me before was untrue. And then record that statement and submit it.
So you're using the term official
This
statement.
is a clusterfuck.
When does
And
a
you can't
statement become
unfuck
official
a
to you?
clusterfuck.
I think once we get down to them understanding that they have lied, if it's a lie, and we start getting to the facts of the statement, it's official. Much of the conversation many times is very superficial, leading up to the information that we want to ask them.
Isn't it true, Investigator Velazquez, that a statement really doesn't become official to you until the things that are being said match with what you want it to be?
Objection, argumentative.
I sustain the objection.
When the information that a witness is disclosing to you does not line up with whatever your other course of your investigation or the information that you have, it's not official at that point, correct?
It could be if that's their statement. If taking statements where clearly the person is lying and they're sticking to that story. And then that's what I'm left with.
Okay. When you say clearly that person is lying, let's just be clear here. When an event happens, Investigator Velazquez, generally speaking, you don't see it happen, correct?
Correct.
Generally speaking, you're not there when it happens, right?
I would agree, yeah.
And the information that you're getting from these people out of these scenes and these investigations, it's information that they, a lot of times, either saw, correct?
Yes,
Heard, correct?
yes,
And they're giving you what they believe or what they're telling you happened, right?
right.
Now, so you don't know from one statement to another, in fact, that a person is, quote, lying, right?
Not necessarily.
Okay.
Many times when you take statements, there's several people who may have observed the same thing.
Okay.
And especially if 2 people or 3 people are involved, if it's several witnesses that are part of a group,
Okay.
and one gives a statement that is in contradiction to the other, then there's a determination on who is telling someone's lying.
With evidence. And it's
So-
standard practice in the Atlanta Police Department.
You're familiar with the Atlanta Police Department standard operating procedures.
Yes,
And that is the guideline in the book that police officers, investigators, and law enforcement in general are governed by in terms of how to conduct their affairs as police officers, right?
yes.
All right. Is there anywhere in the Atlanta Police Department standard operating procedures, because I've looked,
Objection, Your Honor, to testifying.
is there anywhere in those procedures where it says that it is okay or appropriate to record then erase statements?
I don't know. I would have to look through the standard operating procedures. There's probably volumes of documents that I would have to review. I just don't know the answer to that.
And but for 17 years, you operated under those particular guidelines, right?
Yes.
And would it surprise?
For 17 years as a police officer, this man erased witness statements because he felt they were untrue. What the fuck?
You that there's nowhere in the standard operating.
I'm going to object.
To- I haven't finished my question.
He is assuming that's not in evidence when he asks, would it surprise the witness?
Do you know that there is no area in SOPs that discuss?
I'm going to object yet again for the same reason.
Police standard operational procedure or standard operational procedure that he, as a veteran law enforcement officer, should be able to at least say something about. Because if there's nowhere in the SOPs where this is mentioned that it is allowed to erase evidence, statements are evidence, to erase evidence. Let me repeat it to you in the back. For 17 years, this law enforcement officer has erased testimony and evidence. And the guidelines says it's okay in Fulton County. Fuck evidence. Let me record and erase until I get the answers I need. That's evidence tampering.
Do you know if there is any area in the standard operating procedures that discuss statements, to how statements are to be obtained by police officers and investigators?
I know that there is an area that covers when to take a statement, to gather information of an incident. Generally speaking, my experience with reading SOPs they're very general of what you should do in a certain circumstance. If there is a witness, take a statement and then decide whether it's videotape statement, audio statement, written statement. But most SOPs are very general in nature and don't really dial into very much specifics.
And as you're thinking and recalling back to the area that you just testified to in terms of statements, you know that in that area that you just thought of, there's
You're
no.
not going to object to assuming facts not in evidence when.
I stand objection.
No further questions. Thank you, Your Honor. Thank you.
Thank you.
Anybody else?
Sometimes the answer, the question is more important than the answer. And he clearly got through to the jury that Atlanta Police Department erases statements they don't agree with because they feel it is untrue. Here's the thing with eyewitnesses, completely unreliable. There was a test in a university about a decade ago where during a lecture with somewhere between 50 and 100 students, all of a sudden another person comes in, says something for a minute, and then walks out. A few minutes later, the professor stops the lecture and says, okay, can anybody here describe the person who was here 5 minutes ago? And the result, staggering. There were more people have been wrong about the shirt he was wearing, the pants he was wearing, even if he was wearing a hoodie or a suit. It was that different. And yet, eyewitness testimony, for some odd reason, is still considered evidence in trial. Eyewitness testimony is less reliable than lie detector tests, in my opinion.
Yes, Mr. Short.
Detective Velazquez,
Good afternoon.
good afternoon. You just indicated that in your experience, in your time as a detective, you have erased statements before, correct?
Yes.
Okay.
I'm going to object to the questions concerning as relevance.
I'm over the objection.
Now, as part of your duties as an investigator, you also write reports, correct?
Correct.
And the purpose of the reports are to accurately memorialize what's been done in a case, correct?
Correct.
Okay. In these situations where you've written reports and also have erased a witness's statement, do you note in your report that you erased the statement?
No, what I would note in my report is that he lied and then admitted to lying the first time we spoke or in his first statement. And I think it's assumed that it's not available for review because now we then sit down and start talking about the facts of the case.
So you erase statements until you get the answers you want, and then in your report you write that the person lied and then admitted to lying and then told the truth. Seriously? What the actual fuck?
Okay, so when in your reports, you would make some indication that a previous statement was made.
Correct. And if it was obviously a lie, I would indicate in my report that that person was untruthful in our initial encounter. And then subsequently another statement was made and it was memorialized and included in the file.
Understood. You know what discovery is, correct?
I do.
Okay, and you're aware that the police reports that you write are eventually passed along to defense attorneys, correct?
Correct.
And you're aware that statements that are recorded are eventually passed out over to defense attorneys as part of discovery, correct?
Yes.
Okay. You would agree that it's important to know what witnesses say?
Yes.
Okay. In the event of you personally erasing statements, the defense attorneys would have an opportunity to view your report, correct?
Yes.
And see that there was initially a lie.
I'm sorry.
There was initially a lie told, correct?
Correct.
Based on your belief that it was a lie.
Or well, my belief that the person I'm speaking to admitted that they lied.
Okay, fair enough. You would agree, though, through discovery that erased statement is no longer available to the defense attorneys, correct?
Well, it is because it's memorialized in the report.
No. Recorded statements are not the same as memorialized reports. Because there is no way in hell you can get that down word for word as it was said.
Do you give quotes in your reports about what was said in the erased statement?
I could, depending on, the situation. If it was specific to, like, as an example, the color of a car or a time of day that may be relevant. If that was the lie, I would quote that.
And why would you quote that?
Because it would be relevant.
It would be relevant.
That would be the lie.
Right, and it would be relevant and important for defense attorneys to know what was said, even in the lie?
I don't know. I mean, I think my obligation would be to memorialize it and turn it over to the DA's office, and then the legal ease that happens between both sides. I think that's beyond my interpretation.
But you do view it as your obligation to at least memorialize it?
Yes.
Okay, thank you, nothing further.
Any further questions? Any redirect?
No, Your Honor.
May retired Detective Velazquez be permanently or temporarily excused as a witness at this time?
Thank you.
All right, sir, I'm going to permanently excuse you as a witness. I thank you for your time and patience with us.
Okay, that witness, after roughly a full day of testimony, admitted that he tampers with evidence. Cheers.
And
Thank you.
please, 12:30 or thereabout. Ladies and gentlemen, we will come back and get.
All right. Then it is lunch break. And here's the thing. There's no trial tomorrow, tomorrow, Tuesday. So what I will do is keep you all on, make this a cliffhanger. And I will do the rest of today, tomorrow, so we can have something to look forward to tomorrow. Because I've been at it for 3 hours in a few seconds. And hopefully tomorrow I will have more information regarding today's testimony in the Fani Willis debacle. Because Mr. Bradley is at the moment, or has been since 10 a.m., I think, he's been making testimony towards Judge McAfee in the disqualification case against Fani Willis. regarding if what he knows is regarded as attorney-client privilege. So that will also be tomorrow. And tomorrow is Yodi Day. Me and Dave usually are doing the Yodi Aris trial from 2013. Tomorrow you will have a surprise. A really, really nice surprise. I will not spoil it for you. 6 p.m. tomorrow. But between 10 a.m. and noon, 6 p.m. my time, I mean, noon Eastern time, tomorrow, Yodi Day. 10 a.m. to noon, it's this trial, the Young Thug trial. I will do a recap of what happened in the afternoon session. Gigi has a question. Oh, Standing Stones has a question. Sure, go right ahead. Is anything he knows back then still under the client attorney privilege? That is what the judge is determining right now. Because since Mr. Wade took the stand and said things that, because Mr. Wade could have claimed attorney-client privilege and then shut up about anything. Attorney-client privilege and then zip it. Which meant, with all the other evidence in the case, that both Willis and Wade lied. Maybe even lied in court. So what about before he was fired? That is what the hearing today is about. What did Mr. Bradley actually know about the relationship prior to Mr. Wade's appointment as special prosecutor? Exactly. Here's the thing. If the judge says it is attorney-client privilege, we will never find out when the relationship actually started. Then it comes down to credibility between Wade and Willis and the other witnesses. So hopefully, I hope there are some answers tomorrow. I hope there is. But I will send you off to who is live now. Customization, redirect. Who is up? Oh, Feral housewife. You might not know her, but she's a hoot. She is really funny. You need to subscribe to her. So I'll be sending you off to her. And yeah, thank you for allowing me to try to interpret this trial to you all and the Fani Willis debacle. Thank you. And as I always say, hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. All right. I'll see you all tomorrow. Bye-bye.